I'm Mike L. Crocky. I'm an attorney and a member of the Chicago Bar Association, and I practice plaintiff's personal injury and medical malpractice at Leahy and Hosty in Chicago. And I also serve as an adjunct professor of advocacy at Loyola University Law School here in Chicago. And we're here today on this episode of You and the Law to explore some legal issues and regulatory issues that shape the craft beverage industry and provide some insight to amateur brewers and distillers interested in turning their hobby into a business. We're lucky to have with us today two guests, Ashley Brandt and Mike Raspatello. Ashley is an attorney at Goldstein and McClintock, where he practices in a number of areas, including food and beverage law, and has particularly relevant experience representing craft brewers in Illinois and Wisconsin. Mike has significant experience in all phases of adult beverage marketing, having spent years working for Anheuser-Busch, AB InBev, and now runs a craft beer and culture online magazine known as October. Ashley, Mike, welcome to the show.
Thanks for having us.
I gave a little bit of an intro to you, but feel free to talk about, give us a little more background so we know where you're coming from as you discuss the issues today. Mike, go ahead.
Yeah, no, that's, you described it. Being in the beer industry as long as I was, I realized that there was a lack of high-end conversation about beer as a beverage. Beer loses out to wine and spirits when it comes to cachet and culture in the last 15 years. It doesn't have its Bon Appetit. It doesn't have its wine spectator, and that's what we aim to create. So we launched October 4 months ago. It's a joint venture between a VC fund in New York and Condé Nast, the magazine publisher that puts out GQ, Vanity Fair, and Bon Appetit, and so on.
Great, thanks.
Much better than Wine Spectator.
Thank you.
You're setting the bar high. You also pretty much said it. Food and beverage practice is probably primarily what I concentrate on. And I do run a legal blog, libation law blog, that's now turned into foodandbeveragelegal.news, where I talk about food and beverage legal issues, sort of about the topics.
Great. So we're here today talking about exploring craft beverage, craft breweries, craft distillers. When we talk about craft, what do we mean?
That's a weighted question. It's political.
All
as
right.
a matter of fact.
There is a Craft Brewers Association, does have a definition, and I think it's small, independent, and unique, and each of those have a definition. I think small is below 6 million barrels annually, which, to give you some context, it's going to be tough, but the biggest craft breweries that you've all heard of, the Lagunitas, the Sierra Nevadas, they are now beyond that threshold. They would not be considered by the Craft Brewers Association craft beer anymore, also because the second part, independent, I think it's 75% owned by the craft brewer as opposed to a PE firm or another brewer, and all of those guys have been essentially bought out, or at least partially bought out. So we still think of them as craft beer, drinkers still think of them as craft beer, but you probably ask other craft brewers, they no longer think of them as craft beer. That's the definition, but like you said, it's very subjective, it's very political, and it's kind of in the eyes of the consumer.
An industry definition, and then a sort of a snootier industry definition involving artisanal packaging. Does your website actually show the people who make your product on the website? Can individuals following it still get to the root cause of what is artisanal?
Sure.
So craft really developed out of, I think, that portion of what is the greater food movement, which is people trying to, over the past 10 years, understand, comprehend, and come closer to what they eat, why they're eating it, and leaving processed flour and Pringles behind. Not that there's anything wrong with Pringles, we love them, but the idea that food is now becoming something people are interested in, and they want to know where their food comes from and how it's made. And I think that is really a part of this craft movement, and what kind of spawned something growing from what was, I think a smaller sort of geeked out beer movement into a larger craft, something that joined the craft food scene.
Sure. So, in staying away from politics, which we can get into, and we're going to have to get into a little bit as we talk about the regulatory landscape of this. But just from a lay perspective, I think that the idea out there is if a craft brewer is generally considered to be, at least in the mind of the public, somewhat independent or separate from sort of the major manufacturers of adult beverages. Is that the idea that you encounter out there in the world from everyday people?
Yeah, there's three big companies that brew beer in the United States or globally that are sold in the United States, and that's AB InBev, Anheuser-Busch InBev, which is a conglomeration of the biggest brewery in the United States, biggest in South America, and biggest in Europe. Then secondarily, there's Heineken, and then there's SAB Miller, which with those three, I think everyone thinks of kind of everyone beyond that as a craft brewer. And at this point, what we can obviously discuss a bit is how those three are acquiring many of the regional strongholds, as well as some of the kind of more mature craft brewers in that group. And that's what's kind of creating some of the debate amongst consumers, and also putting everyone into an interesting regulatory environment where the law and the politics are inextricably combined in every sense.
Sure. Well, let's take a little bit of a step back, and I'll call it the last 5 years, although I know it's been going on longer than that. But certainly there's been, seems to have been sort of a proliferation of breweries, independent companies. Maybe it's 5, maybe it's 10. I'm sure that you'll probably tell me it's 20 or something longer than that, because I don't really know. But if you can kind of talk about some of the major brewers that have appeared in and around the Chicago land area, and just to sort of set the tone for some of the issues we'll be talking about, what sort of happened with them in terms of maintaining their independence or selling to a larger brewer.
So, when I think of the history in terms of movements, I would definitely say that there was a movement in the mid-90s that spawned quite a few breweries. Some didn't make it, some did.
Sure.
Two Brothers is a Chicago land brewery that I think comes out of that tradition. And then fast forward about 10 more years to where that's when this most recent groundswell really gets rolling. It snowballs downhill into from 2006, 2008 up through 2012, and then the mass growth from 2012 to 2014, 2015 that happened. And in that period, Half Acre, Revolution, those are some of the larger ones. Obviously, about 2 years ago or 3 years ago, Lagunitas came to town.
Yep.
They are, I think, it's a Chicago family that had started the brewery, but they had started it out in California. More recently, some of the darlings of the craft beer world, Pipeworks. I can think of
Moody Tongue, Hopewell.
Moody Tongue, right.
There's definitely more than 20, and definitely more than I can name.
Oh,
so.
yeah. Last count, the Illinois Brewers Guild was saying 168. So 168 in the state of Illinois.
For it to be exclusive.
I would say the most famous, though, remains Goose Island as a Chicago stalwart, and they were also one of the first, if not the first, to be very publicly acquired by one of the big three, being AB InBev. And that was shortly after I started working there, actually, like the first week in 2011. And since then, AB InBev has acquired 10 more substantial craft brewers after that. So they were both a Chicago native and also kind of a benchmark in that second acquisition craze that has happened in the last 5 years.
Goose Island, 1988, is when the check gets written and the brew pubs get started.
What does that mean, brew pubs?
Well,
that's a term of art, right?
Yeah, so according to, anyway, it has a regulatory definition about the number of barrels you produce and sort of how it's done.
Different in every state.
Right, so you have a tap room, you maybe have food, maybe you don't. Your premises for on-premise sales, where you can have people come and drink, are segregated from the space of your brewery where no one else really should be or is allowed to be. And in different states, some mandate food sales, some say no. That's not really something we're concerned with as a state regulator. Like say the city of Chicago cares very much about your tavern and restaurant license, and that's really a factor of where the majority of your sales are coming from. So brew pub, when I think of the term, let's just use it casually for the kind of space where it's a restaurant that makes its own beer.
Understood.
They have food too.
So why don't we take a step back and sort of take a broad look at some federal a federal scheme, the three-tier distribution system, which now that applies equally to all states. Obviously, now I know there are going to be other issues state to state that relate, to how those are enforced and navigated. But just
I assume we're concerned mostly with Chicago and mostly with the state of Illinois when push comes to shove, thanks to the Chicago Bar Association.
Right, and we are, but I think we also have to respect the federal government. So let's talk about the three-tier distribution system.
So the three-tier distribution system is a method of liquor control and management that arose after Prohibition. I don't know if you ever got to see Ken Burns' wonderful series on PBS about sort of the rise and creation of Prohibition, the enactment of the 18th Amendment, and then its repeal by the 21st Amendment. Those issues gave rise then, I want to say 1931, to the repeal of Prohibition. It's, I think, one of the few substances even mentioned in the Constitution, let alone to have two different amendments.
Yep.
One saying yes, one saying no, or no and then yes, where some issue-related activism really did impact the country. But given the 21st Amendment's grant of the rights for liquor importation and control to each of the states, what happened was, this is sort of a nuanced piece of history, there was a book and two different authors. The book was called Towards Liquor Control that came out right around the end of Prohibition as states were trying to consider how they wanted to deal with liquor control, and it proposed one of two different methods, both that involved a three-tier system. One method was state control, where the state would control and keep track of and ultimately be responsible for the sale of alcohol, and the other was sort of a distributed system where you had three different tiers: a manufacturer, a distributor, and then a retailer, and that separation would keep a singular evil from occurring. And this evil is pervasive. It's what the entire system was set up to deal with, and it's an anachronism now, but it was that when you had tied houses, which were manufacturers owning retail, so manufacturers owned saloons, it encouraged drinking, and that was the thought. The thought was, gosh, prior to Prohibition, there was so much drinking, and after Prohibition, we don't want that. So here's a method. These two individuals, Foz, I forget the names now, in this Towards Liquor Control sort of came up with these two regulatory systems that states could adopt or look to. Many states favored the three-tiered system, and then the three-tiered system with some version of state control. A few of the other states went with that, which is why in some states you see state-run liquor stores still.
Is there any current justification for is that a heavy question?
It's not just a heavy question,
yeah,
it's a beautiful one.
Well,
like,
let me ask you a more precise question that's susceptible to an easy answer.
Oh, come on. That's the easy answer.
I don't know if we have enough time to get into that. What is the justification for the continuing three-tier distribution system or laws? People who like it, people who want it in place, why do they say it's important still?
One point of view is that it prevents the supplier, the producer, the Anheuser-Busch from improperly incenting the retailer to favor their beer. So theoretically, you want the bar and their discussions with consumers and their own margins and their own business decisions to decide objectively what products they carry. Without the three-tier system, the biggest guy can throw a bunch of money at a bar and say, you're only going to carry my 50 brands, and that's going to obviously restrict consumer choice. It's going to make craft brewers have a very hard time getting off the ground. So that would be one of the many current justifications for it.
Yeah, I think that's a good one. Out of all the ones that I have heard recently, and I'm against this system. I don't think it's useful anymore. I don't think it's necessary.
I think causes more headache.
Right, and we have
people get around it when they want to. The lobbying is so strong that I can talk through a loophole in a second. But go ahead.
We have antitrust laws right now that were enacted over the course and since the enactment of the 21st Amendment, and that have come into play that protect people from these monopolistic practices. But one very good one is, from a craft brewer's perspective, if I have independent distributors who are separated from mass manufacturers, I never have to worry, or at least I shouldn't have to worry, about finding a distributor for my product. That those monopolistic practices won't affect me, and the other is the sales. I think both those are valid arguments. I think there are counterpoints, obviously, about whether or not they're useful, whether or not other regulations have come along and superseded them, whether or not the laws have superseded them, whether or not drinking practices are even the same nowadays compared to 100 years ago, where we really need to worry about drinking becoming so pervasive that there's a saloon on every corner. You know, there are 10 times, this is a stockyard fact from the Chicago South Side, there were back then almost 10 times as many saloons as there were churches, because they were the places, you know, you still see them in different neighborhoods in Chicago, where they're long rail saloons, but you would go and cash your paycheck there when you worked in the stockyards. You'd go get lunch there. You would conduct all your business there. So drinking was prevalent. But water wasn't as clean as it is now. So there are a lot of reasons for people drinking more. I'm interested in the monopoly workaround.
Well, one recent example that in Texas that has notoriously strict laws on the alcohol regulation side, Anheuser-Busch bought Karbach Brewing, a famous craft brewer in Houston. And there's these carve-outs within the three-tier system where that brewers of a certain size and smaller can operate tap rooms and obviously sell beer without going straight to the distributor. So you brew it in back and you sell it in front, and that's the Taproom Laws. Well, what happens when Anheuser-Busch buys that brewery? Now they've gone over the barrelage limit. So now Karbach Brewery isn't the owner of that brew pub. Anheuser-Busch is. So what do? They can't operate their tap room anymore? Well, Anheuser-Busch just bought that company due to its connection to the community, the thriving tap room. So what they do is there are lobbyists who go work with the Texas ABC, and what they determine is now that tap room has to brew the beer, sell it to a distributor down the road, who then comes back and redelivers it to the tap room to sell to consumers.
Sure. 5
and
feet
so
away.
those are the carve-outs that happen. So what was really accomplished there?
Right.
I'm kind of biting the hand that's fed me by saying that, but it's everyone talks about it, and it's a very obvious workaround, and they have workarounds like that in every state.
It was already the rule in
Yeah.
Florida, very similar
Yeah.
situation where they didn't even have an exemption, and someone brought up, well, hey, wait a minute, how is it that a brewery can have the beer over in its tap room? How is it getting there?
Yeah.
And the distributor said, hey, wait a minute, if it needs to get from point A to point B, that's us.
Yeah.
It needs to rest for a night and then be moved. So if you want it literally 20 feet from your bonded premises to your tap room, you're going to have to give us a cut to be able to take it, sell it, and let you then give it to the public at retail.
Sure. So let's switch gears a little bit and kind of take all this stuff off the table and use a very simple hypothetical that you've got a potential client or a friend or just someone you know who's had a hobby of brewing, and they have the itch to try to turn it into a business. And I want to try to stay on the very, very basic issues that they would encounter, with the understanding that it can be infinitely complex, and they probably have to hire someone like yourself to navigate.
No question.
Okay. First things first, very basic across-the-board business practices that you offer for your clients, whether they are brewers or some other small startup. What are the things they need to be aware of right away as a new business?
I think absolutely the first thing out of the gate is trying to decide how they're going to structure their business, which is really a question of what kind of investment they have, how they're funding it, and in a regulated scheme, how quick they want to try and get to market. Because the longer you take with bringing on investors and the more changes you have to make while you're also simultaneously engaging in a federal and state application process, if you do it the right way. Now, in a second, no one ever does it the right way. And, people
well, I'm
apply,
sure your clients
and then they do after the fact, right? Once they come and get sort of regulatory advice and understand, oh wait, I can't do that. There are so many instances of this, especially in the nascent world of craft beverage, where people just don't realize that federal regulations may control or govern what they're doing. Like there are people who bring liquor in for tastings from outside of the state. There are breweries that only have licenses in California, and they think they can just get beer to a tasting in Illinois or, you know, some other place and don't even think to question, well, wait a minute, you know, are there limits? Are there things that I should be doing?
And this has nothing to do even with
Sure.
intellectual property issues.
Yeah,
No, and it's good,
no.
but I'm saying there's so much stuff. There's
and
intellectual property, there's employment.
Beautiful.
There
Beautiful
are
things.
tax issues. There are a
Yeah.
number of things that almost any business is going
So-
to face, plus all these
Right,
other
so
beverage-specific
the regulatory
issues.
scheme aside, trademarks are probably one of the biggest ones that people have heard about in craft beverage, where because I think what happened was somewhere between 1996 and 2016, branding became such a big issue, and the amalgamation and control of different brands by larger and larger companies became really what many of these major food companies are. They're just brand companies. They may have contracts to produce private label products or to produce the products with factories that are out there, but a lot of times they don't even hold controlling interest in the factories that make, you know, the popcorns or the peanut butters or whatever. They outsource all that, and what they do is control the public-facing portion of this, which is the brand.
What about someone who wants to protect intellectual property related to, say, a recipe or some food? Is it very hard to do?
No, well, this is funny. I just got a case the other day, not one of mine, but one that I found online to have to read. It just came out, but where two restaurants in New York are actually fighting over trade secrets. The new Defend Trade Secrets Act, it came out last year, sort of a brand new method that in the lexicon or the arsenal of copyright protection, patent protection, trademark protection now adds trade secret to protection, trying to figure out where that may fall in the ability to protect something like the secret formula to Coke or the recipes, because prior to that, you're entirely right. I can protect the design on the outside, the bottle, the trade dress. I can protect, you know, the wording, the descriptions that I use under copyright. If I have some crazy novel method for creating this thing, that may be a patentable issue, but the actual flavored product that you get out, what can I do about that? Is that actually something that I can protect or not? And potentially with the Trade Secrets Act, again, the method or the recipe for doing it, you might be able to protect. But if somebody went to reverse engineer or create, you know, another version of Dark Lord or, you know, some famous beer, gosh.
Which ironically is exactly what home brewers are aiming to do, is reverse engineer beer. So I think back to your question, what a home brewer should do, I think the first thing, hope you live in a very independent taproom friendly state that allows you to grow a taproom easily, but also keeps the big guys from finding those taproom loopholes. And the reason I say that is because strategically they found in the last 5-6 years that the approach to growing a craft brewery has changed. Before it was get a little traction at home, but try to become a national brand as quickly as possible, kind of spread yourself thin. And then that was kind of the approach, because the craft boom was happening so rapidly that there was double-digit growth every year. And so the thought was, okay, let's make this one IPA that everyone likes and make sure it's in all 50 states and thousands of accounts overnight. Well, what happens is when the industry softens a bit, you don't have that abundance of cash flow back at home. And as you start losing other states, you can't pay to exist because you don't have that robust business as your foundation. So what's happening is you're seeing a lot of businesses, a lot of craft beers go into other states and then kind of retract back home. And so now the newer ones that are coming out, they're realizing, okay, I'm going to shift the model from 20% sold in my tap room and 80% distributed all over the country to the inverse. So I want 80% of my business to come out of my tap room where I can have the highest margins and I can control the business. And then 20% will be distribution either in that state or in the neighborhood or across the country. So knowing that business model has worked so much better for craft breweries of late, if anyone was starting their craft brewery, they're going to already know this, frankly, and they're going to try to find an environment where they can grow with some kind of sense of buffer and security, so to speak.
And I think the security, yes, the tap room, I can tell you, bar none, amongst all my clients, is a game changer, and it has been, and not just for creating a local presence, which I think is the big thing.
Yeah, connection to your locale.
Absolutely,
it's the biggest thing. Yeah.
It's this authentic craft portion of your movement. You are a community player. You are a member of this region or wherever you're sort of citing yourself in your story. I mean, your brewers, your, you know, Chicago's sort of a weird market because people can be so far away in many different towns and millions of people away, but you know, central Indiana, central Wisconsin, out in Montana, you're probably going to have people located closer in a community, but those taproom sales, hands down, are money in your pocket, given that everyone else is trying to take it out of your pocket along the three-tiered route, you know, to getting to consumer
And I'd like to
sales.
cover two more things very briefly in the last few minutes we have. One is, and maybe this is just my interest, reflects my bias as an injury attorney, but what do these taprooms need to know about dram shop liability?
So,
In the simplest terms.
in the simplest terms, get dram shop insurance. Hands
Dram
down.
shop being, what is that?
A dram shop insurance is a special kind of insurance that basically covers alcohol providing businesses for alcohol-related incidents that may occur on or I think off-premise as well. Like if you get
If someone
right, if someone were to get intoxicated and to go out and God forbid drive and injure someone, that the person who is injured has recourse against the drunk driver, but also against the bar that potentially overserved the person. And this is interesting. You know, this is most states have laws that say you can't serve an intoxicated person.
Sure.
And how do you gauge that? When do you gauge that? You know, do bartenders really understand that? Is that a drink? Does that mean I can have one?
Right. But it's an issue they need to be aware of.
Absolutely.
And we can end with this for folks that are out there either kind of just starting their business or thinking about doing it. What sorts of resources may be out there for them? For example, I know you mentioned the Brewers Association or Illinois Craft Brewers Guild, those sorts of trade groups. Where can they look to find a little bit of support?
The neat thing about the community is that it, up until very recently, and I'm sure it still is in many parts, is supportive. And most people looking to start businesses can contact other brewers, volunteer, you know, intern, get experience working that way to understand things. The Brewers Association, I think October, along with a lot of the other publications, are good places for industry enthusiasts to understand a little bit more about what they're doing. Local brewers or state brewers guilds have tremendous support, and you know, competent counsel, I think, is another good way to go about it.
Yeah, I would agree with that completely. I think competent counsel is huge, not only for potential brewers, but people who are innovating in tangential industries. So the people, I worked a bit in developing e-commerce functionality for the beer industry, which shouldn't be that complicated, but because of the three-tier system is, and these companies relied very much on attorneys like yourself to help work with the states where they were operating and understanding where digital sales lives in a law that was written in 1931, obviously far before you could even imagine what that would mean. So I've seen a lot of startups come to me when I was on the innovation side and say, hey, we worked with this attorney who's worked with the ABC of California or whatever, and we now have this letter that speaks to their interpretation of our business versus the law. And that's helpful to a big company that's looking to do business with that startup.
Sure. Well, on behalf of the Chicago Bar Association, I'd like to thank Ashley Brandt, Mike Raspatello for being guests on our program today. And of course, we want to thank the viewers out there. We hope you enjoyed this episode of You and the Law.